impeachment. So everybody go ahead and get your blueprints ready. Okay. All right. Kareen, you there?
I'm here.
95% of the rules that we have learned in evidence are used for the function of doing what?
Excluding evidence.
This is going to be one of the rules that is not for grounds of excluding evidence, but this is a rule of grounds for admitting evidence, right? Admitting evidence for the purpose of impeachment. All right, Kareen, so everybody remember that impeachment is not a rule for excluding evidence. Okay, so we have some background here, and Kareen, let's go ahead and stick together for a little bit on this. Before we get into all of the rules, it's important to understand the background, right, and know what's going on. So first off, what is impeachment? Can you read that section for me, please?
Impeachment refers to a party's ability to discredit a witness. To impeach a witness is to offer evidence as to why the jury or judge shouldn't believe that witness.
Okay, so in the American court system, right, whether it's a civil case or criminal case, how important do you think witness testimony is? Like, how large of a role does that play in the outcome of a case?
Pretty big.
Pretty large role, right? In a large point, or to a large extent, the outcome of the case depends on the witness testimony and the evidence, right? And that's can be connected. So impeachment is so important to us, guys, as a principle, is because since so much relies on witness testimony and allowing in witness testimony, this section is helpful in determining who can we trust when they come into court and testify as a witness. So that's what we're dealing with in impeachment, is that when one party is called as a witness, let's say it's plaintiff versus defendant, and defendant calls a witness to the stand. Assuming this is not the rare scenario in which you're calling up a hostile witness, right? We'll get into that later. Typically, you're calling up a witness that is beneficial to your argument, right? Is going to help you. Who wants to impeach here? Kareen?
Plaintiff.
The plaintiff, right? The opposing side. If it was plaintiff's witness, plaintiff versus defendant, and then the plaintiff called a witness, then it's the opposite. Now the defendant wants to impeach their witness, right? So it's pretty straightforward. Everybody wants to impeach the other side's witnesses. All right? So that's what impeachment is all about. Now, this next question is very important from an issue spotting perspective, figuring out, is it worth talking about on my essay, or knowing if I can talk about it. The question is, who can be impeached? All right? So in both civil and criminal cases, a witness may be impeached if they take the stand to testify, or if they are the declarant of a hearsay statement that is offered by another witness. All right, let's do a couple of quick examples of each. So witness taking the stand to testify, that's your testifying witness. Any testifying witness may be impeached. A party may impeach an opposing witness, common, but they may even impeach their own witness. And again, that's typically when it's a hostile witness. Calling a hostile witness is somebody that you know is not going to be initially helpful, to have good things to say, but you're calling them for some strategic purposes. Okay. Note, this rule is simple, and you have to make sure you're grasping this concept. As soon as a person takes the stand, you have to realize that one of the consequences and implications of taking the stand is that you may now be impeached. Fred, in a criminal trial, a lot of times this particular decision is made because, see how I can phrase this question for you to see where I'm going with it. In a criminal case, a lot of times the defense will make this decision so they don't run the risk of some negative impeachment evidence coming out. Do you get what I'm going at for? Yeah.
They just don't put the defendant on the stand.
Exactly. Because again, let's say you want to put the defendant on the stand so he can just talk about, hey, I didn't do it. By simply getting up to the stand and testifying, hey, I didn't do this. It doesn't matter what he talked about. By getting on the stand, you can now be impeached. and now they can bring all this different type of evidence to impeach the defendant. As we'll learn here in a second, one of the ways that you can impeach a witness is by showing prior convictions. So imagine just by you getting up there as a defendant and testifying to like, I didn't do this, you now make yourself susceptible to impeachment by even means of prior convictions, which will not be helpful to your case if the jury is now knowing you're a prior felon, right? You have prior felonies. So that is the impact. We all have to understand and realize that by simply taking the stand, no matter what you talked about, you can now be impeached. Also realize you can impeach the declarant of a hearsay statement. So when you're talking about hearsay, as we'll learn here in a bit, you need to know there's a difference between the testifying witness who's bringing it to court and who's the actual author of the statement. Who's the person who actually made the statement? So if plaintiff versus defendant, defending is offering the witness, let's say the witness is Max, to testify as to what he heard Fred say. If that's the situation, Fred, defendant is offering Max to the stand to testify as to what Frank said. Who can be impeached here? Fred?
Max.
Say it again.
Max.
Max can be impeached. Why? Because he took the stand and he's testifying as to what he heard. But based off of this, who can also be impeached? Fred. Remember, I said Max is getting on the stand and testifying as to what Fred said. So he gets on the stand and testifies that, yeah, I heard Fred telling his friend that he was going to the store on the evening of the killing. Well, you're testifying as to what somebody said. And that rule tells us not only can you testify or impeach the testifying witness, you can also impeach the declarant of a hearsay statement. That part of the rule is not the most tested, but it is important to know how this rule works. And that is grounds for impeachment as well. Okay? The party against whom the outer court statement was offered may call the declarant as a witness and cross-examine him about the statement. Yeah, okay. So, next, impeachment on a collateral matter. All right? So, basically, right, the rule tells us here, impeachment on a collateral matter may not be proven by extrinsic evidence or by a prior inconsistent statement. Definition. Collateral matter means the issue at hand is not relevant to the case. So it's like, you'll see this in some examples we're going to do here in a bit, but it's like, we have this whole case about the alibi and the murder, let's just say, and at one point somebody said that, yeah, I was wearing a red shirt that day. Well, I want to impeach this person because I have somebody to testify that they're actually wearing a green shirt on that day. Well, if the color of their shirt is not important because there's not like an eyewitness matching that we need to do with the color of the shirt, but we just so happen to catch an inconsistency on some non-relevant or irrelevant issue, that's a collateral matter. And so you cannot prove, you can't bring in prior inconsistent statements to prove collateral matters, nor can you bring in extrinsic evidence. Now, before we move on, this is also a good opportunity to make sure we understand the concept of extrinsic evidence. Max, what do you think of when you think extrinsic evidence?
Like outside of court.
Outside of court. Can you give me an example then of what would outside of court be?
Like I don't know if the case is going on and it's about a car accident. I guess like the car or something.
Okay, good. So I want to expand that a little bit further. So Max, you are right that proving something by extrinsic evidence is or does include bringing in like other things and other items, right? Bringing in the video recording, bringing in the item. That could be considered extrinsic evidence. Also, bringing in a witness to prove something can also be considered extrinsic evidence. If I'm trying to prove a point and to prove that point, I'm bringing in another witness to make that point, that's extrinsic evidence, right? So non-extrinsic evidence would be just like straight up like questioning, right? So if like Max is on the stand, prosecution versus defendant, Max is on the stand, and I'm trying to impeach Max, and I am impeaching him by just asking him a question like, hey, didn't you lie on your law school application? Well, that's not extrinsic evidence. That's just me asking him a question on cross-examination. But if I then bring in the law school admissions director to then testify that he lied on his application, me bringing in that person to prove that point is extrinsic evidence. So we're going to be dealing with extrinsic evidence here, and that's a good thing to just make sure you foundationally understand is what is extrinsic evidence. And it's essentially when you're going to further steps of bringing in an item or a recording, a document of some sort, or even another witness to prove that point. All right, so that is the background, right? What is impeachment? Who can be impeached? And collateral matter. We have one more section, and that's the methods of impeaching. Max, can you go ahead and run through the list for me? What are the 7 methods of impeachment?
Yeah. Bias and motive, then sensory or mental defects, contradictory facts, prior inconsistent statements, convictions, prior bad acts regarding truthfulness, and calling on witness.
Perfect. So we have this nice organized list and realize that once you can impeach somebody, these are all of the different methods and means in which you can do so. And make sure you're really grasping that concept. Look at number 5. You can literally use a conviction, a prior conviction, to say we cannot trust this person on the stand here today. Right? So a lot of these things we may not want to naturally accept and or agree with, but you need to understand that it is acceptable for these purposes. Okay? So there we go. There we are. Those are the methods of impeachment. So now what we need to learn is how does each method work? The first one is bias/motive. A witness may be impeached by this evidence of bias, motive, or self-interest. Note, look at the relationship between the testifying witness and the party to the case that the witness is testifying for. Example, D calls Chris, D's cousin, to the stand without identifying him as his cousin. On cross-examination, the prosecution asks Chris, "Aren't you the defendant's cousin?" This is admissible as impeachment for bias, right? That is impeachment evidence of bias. The bias comes from the fact that they are family members and you have reason to testify in a favorable way for this person. Now, again, is this something where it's like he actually has to be biased? No. Is it something where, we know for sure that Chris, whatever he's talking about, isn't telling the truth? Absolutely not. But the other side gets to do things within their power to discredit this witness. It's up to the jury for them to then determine if they believe Chris or not. But the opposing side is allowed to impeach this witness by proving that that this is his cousin and therefore he might have bias. Okay? So, rule for extrinsic evidence regarding bias and motive. Extrinsic evidence is allowed as long as the witness is presented with the facts that suggest bias or motive and is given an opportunity to explain or deny. Let's kind of hold off on going through any additional examples or questions on that, just because that extrinsic evidence rule for bias or motive is not really commonly tested or not really seen a lot. Test tip. Bias and motive is often tested on MBE, rarely on essays. Okay, so let's do our first couple of quick examples, or hypos. So go to your hypos now. I'll run through these pretty quickly. Kanye's on trial for murder. So it's prosecution versus Kanye. Kanye calls Jay-Z to the stand. Jay-Z calls Jay-Z to testify that Kanye was with him the entire night of the murder. All right, so it's an alibi witness. Prosecution crosses Jay-Z and asks him, "Aren't you business partners with Kanye?" All right, so when we're diagramming and we're illustrating cross-examination, I'll draw a line like this and then do a double X. Double X is the symbol for cross-examination. So, Max, why is this a proper attempt to impeach by bias or motive?
Yes, because it's showing that they have a previous relationship with each other.
Exactly.
Bias. Yeah.
And why would the fact that they're business partners provide bias for Jay-Z?
Well, because it would show that they have already have a connection together, so maybe he'd be willing to lie about something or just in that range of what he could do.
So that way, you got to just all the way connect the dots here. You have it, but it's like specifically, why would Jay-Z have reason to lie on behalf of Kanye? So can you go?
he would lie about Kanye because it could affect their business together, so he doesn't want Kanye to get in trouble.
Exactly, right? So here, this is used to prove bias or motive. They're business partners, and if Kanye goes away for murder, that could negatively impact and affect their business. So again, this should be admissible for the purposes of impeachment. All right. Now, Kanye is on the trial for murder. Prosecution calls Sean to testify. He saw Kanye leave the victim's home on the night of the murder. Okay. So now we have a prosecution witness. Prosecution is calling Sean. Okay. He saw Kanye leave the victim's home on the night of the murder. Kanye crosses Sean and asks him, didn't Kanye fire you from his record label 2 months ago? All right, so again, this is bias or motive. Why is this bias or motive? This would be motive, and you're providing motive for why Sean would testify against Kanye in a negative way, because he may be upset because he got fired by Kanye 2 months ago. So that would be motive. Like, hey, you're bringing the guy that just fired him. He has all the reason to make up something against my client. That is cross-examining and impeaching, right, for the purpose of proving motive. All right. Now, in both of these hypos, Max, were we dealing with extrinsic evidence?
Yes, because we're calling out outside people.
No.
Well, no. Actually, no, because it's just questions. Yeah.
Exactly. We're dealing with the original witness, which is just like, right, your original witness. But when it came to the impeachment of these witnesses, they were both on cross-examination. So that's what I was telling you. Bias or motive, the way we'll typically see it is through cross-examination. Okay? So just as a reminder, though, that rule now, it says extrinsic evidence is allowed as long as the witness is presented with the facts that suggest bias or motive and is given an opportunity to explain or deny. So more or less, that is typically the case, unless somehow they're just like try to bring in some extrinsic evidence and then just end it right there. But you got to give that person an opportunity to explain or deny. And obviously, on cross-examination, that person will be able to address it. So it's not extrinsic evidence, but they are explaining or denying and addressing that impeachment evidence. But instead of cross-examination, if they wanted to do bias or motive by calling Kanye to the stand to testify that, hey, didn't you fire Sean 2 weeks ago, right? But then you don't give Sean an ability to say, hey, no, but even though you fired me 2 days ago or 2 weeks ago, I am not lying about this, and I am honest. I'm not even upset about that. Actually got a better job, etc. That's the type of opportunity to explain or deny that they're referring to. But again, they don't really focus on the rule of that exception all too often. All right, so moving on. Next, sensory and mental defects. All right, there's no hypos for this one, so we can just run through the rules really quickly. This is the one where you're impeaching somebody because it's like, well, can you really see what you're saying you saw, right? Can you hear well enough to testify as to what you heard? So let's say it's DeAndre versus Matt regarding a car accident, and then Matt is calling Emily, who is testifying as to what she saw. And then on cross-examination, I say, well, Emily, don't you wear glasses because you can't see well? And didn't you forget to wear glasses on the day in which you're saying you saw this accident? Well, so now I'm impeaching her I'm discrediting her based off of sensory and mental defects, that you can't see well and you're testifying as to what you saw. That can apply to other senses as well. That can apply to hearing, right, vision, things of that sort. Okay? Note, have seen rule before that says you can't prove a sensory mental defect by reputation evidence of the witness having a reputation for defect. Okay? So you can't prove it by saying they have a reputation for bad memory. Rule, extrinsic evidence is allowed. Test tip, rarely tested. All right, next one is contradictory facts. This is another method for impeachment. Contradictory facts, and we're going to see an example of this soon, so here's just the rule. A witness may be impeached by facts that contradict the witness's testimony. Witness's testimony is saying X, well, I have Y facts that contradict that, so I want to bring in Y facts to contradict the testimony of the witness. Okay? Contradictory facts. We'll come back to that in our hypo in a second. Let's get to now prior inconsistent statement where we see we have a chili pepper. This is a heavily tested rule. Okay, so let's first off understand, even by title, what we're dealing with here. The title is prior inconsistent statement. Matt, if the title is prior inconsistent statement, we know that this section will only be triggered if we're dealing with at least how many statements?
2 statements.
At least two statements. At least two statements. What we're going to have for our 2 statements is one statement being made at trial, during trial, and one statement made before that's being brought in to impeach the one made at trial. Okay? So, for example, it's plaintiff versus defendant. Defendant gets up, and then we'll see in the example that we're going to do here in a second, he gets up and takes the stand and says that, hey, the light was green. Well, plaintiff wants to bring in Adam to testify that outside of court 2 weeks ago, he told me the light was red. Well, we have the one statement that was made by D in court. Then we have Adam testifying as to what the defendant said earlier outside of court. This is the prior inconsistent statement. We're not focused on admissibility of this guy or prior inconsistent statement. This is just live testimony. Hey, yeah, I had a green light at the scene of the crime. This is the prior inconsistent statement. And then you're trying to argue whether or not you'll be able to label this as impeachment of the defendant. Okay? So here's how this works. Let me ask a question to get us going. Matt, do you think prior inconsistent statements are always admissible?
I don't think so.
So this is one of the rare scenarios in which you have an absolute situation, guys. Make sure you remember from this moment on, prior inconsistent statements in the world of evidence are always admissible. The question is, though, for what purpose, or which purpose, or how many purposes, right? All around the purpose. Now, here's how you determine the purpose in which you can admit the evidence. You look to see if the prior inconsistent statement, not the one made at court, but the prior inconsistent statement, you look to see, was this made under oath? Made under oath? If the answer to that is yes, it was made under oath, then you can bring this in for substantive and impeachment purposes. If it was not made under oath, you can only offer that statement for impeachment purposes. And I'll break down what impeachment purposes are versus substantive purposes in a second. But first, Matt, now that you see this, why am I saying prior inconsistent statements are always admissible?
Because at the bare minimum, it'll be allowed in to impeach a witness.
Exactly. At the bare minimum, it can always be used for impeachment. Impeachment has the function of discrediting the witness. So sometimes if you can only offer it in for impeachment purposes but not substantive, what you're saying there is you're telling a jury, I am not submitting this evidence for you to believe the contents of it. So I'm not offering this evidence to prove that the light was actually red. I'm only proving or bringing in this evidence to show that the defendant is a liar. That's impeachment purposes only. But if you can offer it for substantive reasons as well, that's where you're telling the jury, well, I get to also tell you to take this for its substance and believe that the light was red. Matt, in real life, if we're in trial and the attorney is allowed to bring this in for impeachment purposes only and says, hey, I'm offering Adam to prove a statement that D said that the light was actually red. But I only want you guys to take this for the purposes of impeachment, to believe that the defendant is a liar. Do you think there's a chance and a probable chance that the jury is actually going to take that on their own for substantive reasons as well?
Definitely.
Definitely. Are we concerned with that for the bar exam and for determining the outcome to our questions?
No.
No. So do not get
You would applaud the attorney for doing that, right?
exactly. In this case, we're applauding them and we're knowing the strategy and how we need to get things in. And so, yeah, you're kind of tipping your hat to like, all right, you found a way to get that in. And even though we know that they're going to do it for substantive reasons, yep, you're going to do it by saying impeachment only because it was not made under oath. So I want to give that lesson to, again, for those that maybe just struggle with understanding the game, right, of evidence and understand that this is a game. And Matt just acknowledged that. You're going to like tip your hat to the attorney. All right, this was not under oath. He can go ahead and eloquently say that this is for impeachment purposes only, but it's like, man, he got this great evidence in as well. Okay? So let's go ahead now and do some examples. That pretty much did our general rule. Okay? Let's go ahead and do some examples. Matt, can you go ahead and read the base facts for number 1 for prior inconsistent statement?
Eric and Haley decide that they are going to get lunch together after bar prep class. They hop in Eric's car and head to Chipotle. On the way there, Eric gets into a car accident with Ariel. Ariel then sues Eric for negligence. At trial, Eric takes the stand and testifies that on the way to McDonald's, he had a green light at the intersection where the accident occurred.
What type of testimony did Eric just get up there and offer?
You think personal knowledge testimony?
Yeah, we're going to label that as live testimony, guys. And there's typically no big issue with live testimony. So he got up there and testified as to what took place, okay? Typically, live testimony doesn't trigger a lot of issues in and of itself. So live testimony, and the focus here is on the fact that he had a green light. All right? Now, we have all of these now examples, A through F, right, to test our impeachment rules. So let's go from, okay, and just to get grounded, A versus E, and it's for car accident, yep, for negligence. Okay, and so who took the stand here, Matt?
Eric took the stand.
So who's subject to impeachment?
Eric.
Perfect. All right, so, and for all of these hypos, guys, I made the change here, but for A, B, C, D, and F, it says the prosecution does this, the prosecution does that. Whenever it says the prosecution, that is Ariel, right? Didn't switch plaintiff with prosecution. So it's supposed to be the plaintiff, but you can be detailed too and just say Ariel. All right, so go ahead, Matt, and read A for us.
The prosecution calls
Ariel. Just told you.
Sorry. Yeah, I apologize. I was already looking at it while you were talking. The prosecution calls Ariel to the stand.
You just did it again. Ariel calls Haley to the stand.
Ariel calls Haley to the stand.
Yeah.
Who testifies right after the accident occurred, Eric shouted out that he couldn't believe he just ran a red light. Is this admissible under prior inconsistent statement? And if so, for which purposes?
Okay, so really quickly, Matt, let's get grounded in this. Prior inconsistent statements require 2 statements, an in-court one and an out-of-court one. The in-court one was the live testimony that he had a green light. And if he had a green light, makes it less likely that he was negligent. The prior inconsistent statement here is that he told Haley that he had a red light that he ran. And then now Ariel wants to bring that in to impeach. Prior inconsistent statement, guys, works when the statement was made by the same party, right? If it was a different party, it's not a prior inconsistent statement. You can only have that if it's by the same party. Here, it was Eric's statement again, so therefore this rule is triggered. It's a prior inconsistent statement of this witness, of this person. Now, we have to see if this would be admissible, and if so, on what grounds. Matt, what's the answer to that question? Will this be admissible, and if so, on what grounds?
Well, as I answered earlier, prior inconsistent statements are always admissible, but it would only be under the grounds of impeachment because this was made after the accident occurred and not under oath.
Exactly. What does it mean to be under oath?
It would be something like, I guess in some sort of court proceeding, so like a deposition, and a grand jury or a prior court proceeding of some sort.
So from that, would you say that it's like more common to have a not under oath or under oath prior inconsistent statement?
Personally, I've seen a lot of questions for both, but I think it would be out of court.
Yeah, and then I guess from that perspective, you could definitely have questions, and maybe not so much more common. But which one is there more possibility for? And there's more possibility for a not under oath because that accounts for all statements outside of the one specifically that were in that moment where it's like hand was over book and this was made right under oath, which typically, like you said, is when you're dealing with actual court proceedings of depositions or actual hearings and grand jury hearings and things of that sort. So this was made at the scene of the crime, not under oath. Therefore, it can only be allowed for impeachment purposes. If that was an MBE, you were saying admissible for impeachment purposes only. All right, next, let's go with Sasha on B. So for B, it's similar, but now it's saying that the prosecution is calling Officer Billy to the stand who arrested Eric. So now we have an arrested Eric right after the car accident. Billy testifies that right after Eric was arrested, he said, "I can't believe I ran a red light." Is this admissible under prior inconsistent statement? And if so, for what purposes?
Impeachment only?
Good. I tried to throw you off, Sasha, and you felt it, and you didn't get thrown off. Here, I changed it to where it's a different testifying witness. That's not that big of a deal. But now the statement wasn't made in the car to his friend, but rather after being arrested. But is one under oath at the time of their arrest, Sasha?
No.
No. So for that reason, the answer to the question of made under oath is still the same. This was not made under oath, so it will be allowed but for impeachment purposes only. So again, in scenario 1 and 2, what Ariel cannot do is say, jury, we want you to take this evidence also to believe that the light was in fact red. She cannot. Right now, all she can do is say, I want you to take this evidence to see that Eric is a liar. All right. You can take a note in your blueprint if you want. If not, it's also in your answer already. The only times that you're really practically seeing where it's made under oath is if this prior statement was made at a deposition, a grand jury hearing, or a previous trial. There's other things as well, like Matt said, court proceedings in general, but those are the 3 common ones. Deposition, grand jury hearing, or previous trial. All right, C. Let's stick with you on this one, Sasha. After Eric testifies, the prosecution seeks to confront him with his statement made on a deposition that his light was red. So then now you're admitting this deposition that the light was red. Right? Is this admissible under a prior inconsistent statement now? And if so, for what purposes, Sasha?
Both substantive and impeachment purposes.
There we go. So now again, Ariel gets to now say, we want you to believe, jury, that the light was in fact red, and we want you to also see that Eric cannot be trusted as a witness. He is a liar. Cool. D. After Eric testifies, the prosecution calls Eileen to the stand, who testifies that she observed the accident and Eric ran a red light. Is this admissible under prior inconsistent statement? And if so, for what purposes? Matt, back to you. Why are you staring at me like that, Matt?
Did you say you froze for me? Can you say that again?
Oh, okay. I was saying back to you on this hypo. Did you hear the facts of the hypo?
No, can you say it again? Your
Yeah.
whole screen froze for me.
Oh, okay. No worries. So after Eric testified, the prosecution calls Eileen to the stand, who testifies that she observed the accident and saw Eric run a red light. Is this admissible under prior inconsistent statement? And if so, for which purposes?
I don't think so, because I don't think it's It's just saying that she testified or that she observed the accident, and it's not talking about what Eric talked about.
Exactly.
So about prior inconsistent statements.
There is no prior inconsistent statement. The first statement is his testimony at trial that the light was green. Now, what is Eileen's statement? Eileen's statement is to what she saw that is inconsistent with that. But it's not a prior inconsistent statement made by Eric. So this one was like, don't move too fast. This is not a prior inconsistent statement. There are not two statements made by the same person that are inconsistent. But this will still be admissible for impeaching Eric, but on a different grounds. What rule might this be, Matt, that we've talked about already?
Would it be the facts itself? Because she's saying that the light was red where he's saying the light was green.
Exactly. So that was the other method of impeachment, which was contradictory facts. Contradictory facts says a witness may be impeached by facts that contradicts the other witness's testimony. Here the testimony was that the light was green. Eileen is presenting facts that that are inconsistent with this or contradict this. This is admissible under contradictory facts. Okay? So that's your example of contradictory. All right. So then now let's go to E. Let's go back to Sasha. Sasha, it says, after Eric testifies, the prosecution then calls Officer Billy to the stand, who testifies that after the accident, he questioned Eileen, an eyewitness, and she told him that Eric ran a red light and caused the accident. So a lot of parties going on, but is this going to be a prior inconsistent statement? And then Rosemary, I see your question. I'll get to it here in a second.
No.
So this one is, right? It said it's calling Officer Bryant, or Officer Billy, excuse me, to the stand to say that he questioned Eileen and then that she told him, an eyewitness, and she told him that Eric ran a red light and caused, oh, hold on one second. I'm sorry. I read that one different. So it says, after the accident, he questioned Eileen, an eyewitness, and she told him that Eric ran a red light. So that's basically the same thing as her getting up and saying he ran a red light. Well, now it's just that she told Officer Bryant or Billy that he ran a red light, and that's the same thing. There's no prior statement by Eric in that fact pattern. Okay? So it's Officer Billy testifying as to I's statement.
Well, the question says, is it admissible under contradictory facts?
The first question is it admissible under prior inconsistent statement? And if so,
Right.
for what purposes? And then, is this admissible under contradictory facts? So this, again, will be admissible under contradictory facts. Yeah. But the first question of, is this a prior inconsistent statement? That answer is no. Okay. A couple of questions. First off, Rosemary.
Yeah, I'm wondering because here it says if the contradictory fact is a statement, it does not need to be made by the same party. So in example D, it says that she saw that he ran a red light. Is that a statement? Because to me, that doesn't seem like a statement. Example E, where she told the officer that
Yes.
he red light is a statement. So I'm just confused as to what's a statement and not.
Well, I think you got it completely right. In the first example, she just went up and gave her own live testimony of what she saw, and that was contradictory facts of what took place. And in the second hypo, it was Eileen's statement to Officer Billy that's being offered. That was not made by the same person, but that's okay under contradictory facts. So therefore, it's still admissible as a contradictory statement.
Okay, thank you.
You're welcome. Jordan?
Okay, I'm still kind of confused on D and E how those are not prior inconsistent statements because I know you said for E there's nothing in the fact pattern to suggest that there was an inconsistent statement, but it starts off after Eric testified.
Yeah, let me help you out on this. So who took the stand originally to testify?
Eric.
So who are we trying to impeach?
Eric.
The only way we can impeach Eric with prior inconsistent statement is if we have another statement by
him.
Exactly. You can only impeach somebody by prior inconsistent statement if you have another statement of their own to impeach them with. In examples D and E, Jordan, there are no additional statements by Eric, these are either things observed by Eileen or statements made by Eileen that you're using to impeach Eric. And you're no longer using prior inconsistent statement if that's the case.
So even though it says after Eric testified, are we going off number one in the original
Yeah.
background?
So Eric takes the stand and testifies, right?
Yeah.
So the only way you can you can impeach Eric with prior inconsistent statement is if you can point to a previous statement made by him that's inconsistent. But you're thinking of that live testimony part. That's just what is grounds for his impeachment, that he took the stand so he can be impeached. And he testified to this being green, so that's the content of it. But when you're then seeing what are you using to impeach, you're using, in this regard, either Eileen's eyewitness testimony or Eileen's statement, neither of which are Eric's statement to use prior inconsistent statement.
Well, I'll come back to it after because I don't see the difference between C and D. I'm not understanding that part.
All right, so I'll just do C one more time, and then after that, then stick around afterwards, and we'll see if we can get it. But for C, it says that after Eric testifies, the prosecution seeks to confront him with his statement made on deposition. So in C, what are they offering? Not Officer Billy saying what Eileen made. They're offering a deposition, and in that deposition, it's what Eric said. So again, look, on our diagram here, Eric is on both sides, right? So that can also help from a diagram perspective. And those other two hypos that we did, D and E, we're focused on what Eileen either saw or said.
Got it.
Cool.
Thanks.
All right, so the last one is F. The prosecution, Ariel, calls Haley to the stand. So Ariel calls Haley to the stand, who testifies that before we left for lunch, Eric told me we were going to Chipotle for lunch, not McDonald's. All right? So Haley's testifying as to what Eric said. But in his live testimony, not only did he say that the light was green, he also testified, if you look back at those original facts, he also said that they were going to McDonald's. Well, Haley's testifying that Eric had told her that really he was going to Chipotle. All right. Rosemary, what issue, what rule are we raising with this fact pattern?
Hearsay?
No, well, we're not going to get to hearsay just yet. Yeah, these are out of court statements, but let's stick with impeachment. First off, this is a prior inconsistent statement, right? You had statements made by Eric at trial, and now you're bringing up previous statements by Eric as well that are inconsistent. Huh?
Collateral.
Yeah, collateral matter. So, part of his live testimony was that he was going to McDonald's. Now, with regards to this whole entire case, is the restaurant that he was on the way to when causing this accident, is that really an important material fact?
No.
No. So here, this is what we call impeachment on a collateral matter. Like you're trying to catch somebody and trip them up on them being inconsistent on something that's not important. So maybe he slipped up and said Chipotle or McDonald's. He said McDonald's when really he was going to Chipotle. But we're not going to allow prior inconsistent statements to impeach on a collateral matter like this. You can only determine that something is collateral because it's not a material fact. And here, the restaurant that he was going to when causing the accident is not something that's material. So therefore, this is not allowed as a prior inconsistent statement for impeachment purposes because it's on a collateral matter. Okay? Does that make sense, Fred? Okay, cool. All right. So let's move on from prior inconsistent statement. Before we move on, any questions? Yeah, Miriam?
I have a quick question. So with collateral damage, besides
collateral matter,
matter, besides of it being material, if it's already been proven, and this is just another way of making the point, is that also grounds for it being barred?
I didn't follow that question. Because you're saying if it's not material, the whole thing that something is a collateral matter is because it is not material.
My question is, let's say that it is material.
Well, if it's material, then it's not a collateral matter.
Okay, so what I was trying to ask is, if it is material, but if there was already evidence provided to make that point, would the collateral rule stop this piece of evidence from getting admitted?
Yeah, I have to see if we can like at some point kind of I wouldn't even want to do it now to crowd your brain with it while we're going through the rest of this material, but that what you're saying does not represent anything I can say I'm familiar with seeing. But if you want to come up with a hypo where we can get a little bit more concrete with it as far as like what took place, then we can try that after class. Okay, cool. Okay, so prior inconsistent statements. Let's go ahead and move on. Jordan, as I'm erasing this, are you understanding for sure where you were not understanding that a second ago? Is it clear now?
I guess basically what you're saying is that the difference between C from D and E is that D and E never said that. I'm just looking at this term where it says prosecutor seeks to confront him with his statement made on that. The fact that D and E didn't say anything about his statement is why it's not
exactly.
But I was thinking of with number one, the first where it says number one, it says at trial Eric takes to stand, blah blah blah. I thought we were going off of that for each question. So
we are for each question. Eric originally took the stand.
Right. Yeah. So if E says after Eric testifies, how is that still not prior?
When it says after Eric testifies, it's regarding that original testimony from the base facts, not an additional testimony. It's after that testimony referred to in the base facts.
Got it. Thank you.
All right, cool. So let's now move on to the next style of impeachment, okay? And that is convictions. Now, again, realize, although it can be pretty detrimental, and a lot of us, even me personally, I feel like this is a very unfair area of evidence law. Ultimately, what we're saying is that once somebody is impeachable, you can use prior convictions of theirs to show that they cannot be trusted. And to me, that obviously has so much inherent unfair prejudice, because as soon as you say somebody is a prior felon of some sort, that can just really inflame the emotions of the jury. And right, just because somebody created, I don't want to get too deep into it because my way of thinking is not accurate, but I just want to prep those for those that may feel that same way, and that you need to wrap your head around the fact that oftentimes convictions are used to impeach people, whether it's the defendant himself or a defendant's witness. Okay, so to understand this section, guys, we can actually go ahead and just look at the chart that we have for this. This chart is going to make this very easy. With this impeachment section, you really want to make sure you just understand the flow and which standards apply and what the likely outcomes are. I'll talk about how that makes sense here in a second, but you really want to game this section for the bar exam. There's a lot of rules here, but they're tested in the same way. All right, so looking at our chart, okay, when you're the whole question here is, can we use the conviction of this particular type of felony or this particular felony to impeach the defendant? So it won't always be yes. You won't always be able to use a conviction to impeach somebody. So there's at least a question of will we be able to under these circumstances? And as you see in this top right corner of this document, there are two steps. Identify what the applicable test will be under these circumstances for this felony. And then 2, apply the test and determine admissibility. Okay? So the first question we ask ourselves is, are we dealing with a felony or misdemeanor? Right? So most questions, 95% of them that we're going to get are going to be dealing with felonies. So for a second, you can almost put your hand over the whole misdemeanor side. We're going to ignore that for a second. Once we get to the felony side, Rosemary, what's the next question that we ask ourselves in theory?
Is it crime and falsity or non-falsity crime?
Exactly. And so just to ground ourselves again, it's plaintiff versus defendant. Let's say the defendant, or prosecution versus the defendant. The defendant takes the stand, and now the prosecution wants to impeach this defendant. And let's say that this defendant has committed a felony in the past and has been convicted of it, right? So now the prosecution wants to bring that in against the defendant. The first thing we're going to look at is that felony that he's been convicted of. Was it a crimen facie? Crimen facies are crimes, in this case felonies, that involved dishonesty, right? So the typical type of crimen facie is going to be fraud. Oh, and then again here, in your chart in the bottom right corner in that box, you have the popular types of crimen facie crimes: perjury, criminal fraud, larceny by trick, false pretenses, embezzlement. Those are all crimes that involve dishonesty. Now, obviously, we're in the world of dishonesty and not being able to trust somebody. So you can imagine as we get through this chart that if you're dealing with a prior felony that's involving honesty, then chances are this will likely be admissible to impeach the defendant. All right. So the next question, let's say that this is a crimen facie. Rosemary, what's the next question we want to ask ourselves?
Within 10 years or outside of 10 years?
Exactly. You want to look at how old is this felony conviction. Without even looking at this chart, Rosemary, right? Look at me for this one and just thinking practically. Is it going to be more likely that we're going to allow this conviction to come in if it's fresh and within 10 years, or less likely if it's fresh and within 10 years?
I believe if it's fresh, then more likely to come in.
Right, which makes sense, right? Oh, you just committed this perjury 2 years ago? Yeah, conviction that's going to come in and show we can't trust this person. You just lied on the stand 2 years ago. But if it's something that is older, right, longer than 10 years ago, then it's just like, ugh, it's just not as good, right? That's a long time ago. People change, right? So if it's older than 10 years, without knowing what exactly the standard is going to be, do know that it should be a harder standard. Now, it says here, if you have two great things in that this felony is a crime of dishonesty and it is within 10 years, it's always admissible, right? That's ready to come in. That makes sense, guys. It's a crime involving dishonesty and it's within 10 years. Now, if you have one good and one bad in the sense that you have, it is a crimen facie, but it is old and it's longer than 10 years ago, then here you apply reverse 403. I don't want to get into this too crazy right now, right? We can always have some questions for this in office hours or even after class, but just think about it. From the basics, we know that regular 403, which was legal relevance, had a presumption of what, Fred? Admissibility or inadmissibility?
Admissibility.
So if we're dealing with reverse 403, that means we're dealing with the presumption of
Reverse or inadmissibility.
Exactly. We're dealing with the presumption of inadmissibility, right? And it makes sense. This is a crimen facie, but it's 10 years old or more. So therefore, we're on the presumption that we're not going to allow this in. So in most scenarios, if it's a crimen facie that's older than 10 years, we're probably going to exclude that. All right. So then you have non-facie crimes and you have another breakdown. So non-facie crimes, Rosemary, can you give me an example, right, of now we're trying to impeach the defendant with a non-crimen facie? Give me an example of a felony that would be a non-crimen facie.
Maybe like robbery, burglary, murder.
Perfect. So let's say this is robbery. All right, cool. So we're trying to now impeach the defendant with a non-crimen facie. Let's start off with the common scenario where a non-crimen facie is within 10 years. Do look and notice that there's two different rules depending on who you are impeaching. Rosemary, who are the two options for who you're impeaching?
Either the defendant or a non-defendant witness.
Exactly. This is prosecution versus defendant, and defendant is calling himself to the stand, so therefore you're impeaching the defendant. If the prosecution versus defendant and the defendant instead called Miriam to the stand to testify on his behalf, then that's when you're impeaching a non-defendant witness. So which scenario you have with this crime not in facie determines the standard that you'll be using, right? So for robbery and impeaching the defendant, you have the standard of probative value is greater than the prejudicial effect, okay? So it says easier test than 403, good for the prosecution. So this is good for the prosecution, meaning that most times in this scenario, robbery, right, non-falsy within 10, this is going to come in against the defendant. Guys, let me teach you the magic of this question to be able to analyze this quickly on MBE in the essay. When it comes to this scenario, the defendant, non-falsy within 10, you want to compare what the felony is with what the underlying crime is. If the underlying crime, let's say, was robbery, Rosemary, do you think that this then felony is going to pass this test for coming in?
I'm sorry, can you rephrase that question?
Yes. So if we are impeaching the defendant witness for felony within 10, the underlying felony for this crime is robbery, and the conviction that we're trying to use to impeach him for is also robbery, do we think that's going to pass this standard and come in?
I think it will come in.
The answer is no. And I saw a lot of heads shaking like, yeah, it'll probably come in. And here's the reason why. It's that this is too prejudicial. Can anybody, for some brownie points, tell me why this is too prejudicial to allow this in? Clarence?
Because you can't use evidence of previous acts of doing the same thing to prove that they did the same act this time.
And it's exactly, and they obviously won't be arguing, Clarence, that they are doing it for that purpose, but that is the unfair prejudice that you have in this scenario. If you're using a felony of robbery for the purposes of showing that we can't trust this person, well, there's too much risk of unfair prejudice because he happens to be on trial for robbery. So what is the jury likely to do? The jury is likely to then take this as he is guilty of this robbery because he's done it before. So when you're doing this standard, right, of impeaching the defendant, you need to ask yourself, how similar is this felony to the felony at hand? In this case, it's the exact same one that is too prejudicial. Too prejudicial, so therefore, it does not pass the standard where the probative value is greater than the prejudicial effect. Now, Yadi, if I change this to he is on trial for robbery, and I want to show that he was convicted of murder within 10 years, do you think this is going to come in?
Yeah, because it's not related.
The
crimes are not related.
And therefore, there's not this like risk of unfair prejudice. Now, again, this is where some of us just may not be really buying into it, but you have to accept it. You're like, how is this murder even probative of this fact of this person being a liar? Here's the generic argument if you're on an essay of what you make. If this person has been convicted of a serious felony like this, they show that they do not conform to the laws and rules of society, therefore making it less likely that we can trust that person. That is this generic argument. Again, right? Up to you for your personal choice as to how much you buy it. But for the bar exam and how these rules work, that's the connection they're making as to why we're able to use this to impeach this person. And typically what you'll see, honestly, is a more common scenario is the opposite. It's like they're on trial for murder and they want to bring in the felony of the robbery. So here's like a takeaway for the MBE to make sure you remember all of this. When it's this situation where you're impeaching the defendant and it's within 10 of a non and falsy, as long as it's not the same or similar crime, it should come in under that standard. That's your takeaway. Okay? Now, this situation is not tested as much, but let's say now you're trying to use a felony to impeach Miriam, the non-defendant witness. Well, there the standard is just simply 403. And we know with 403, there's a presumption of admissibility. There's no like real risk of unfair prejudice because she's not on trial. So we're not even worried about same or similar incident if it's of Miriam because she's not the defendant here. So chances are, you know, any felony here within 10 is going to come in against that non-defendant witness. Okay? So again, as much as this chart is helpful, the best way at really navigating these rules is going to be just like this understanding that I'm trying to translate over to you guys right now. All right. Now, Rosemary, back to you. If we had two negatives in the sense that this is not a falsity and crime and this is outside 10 years, what are we going to do?
If it's not, and if it's outside, we're not gonna admit it.
We're going to apply reverse 403, and chances are we aren't going to allow it for impeachment. There's a presumption of inadmissibility there. Okay, so there we go. We made it through all of the felony side. Misdemeanor, you guys can go through that on your own. Really not tested all that often, but there is your basics, and it's pretty straightforward based off of understanding the felony side. It's not complicated at all. You can see there's a lot less information there. So let's go ahead now and go through our hypos. All right, so let's go with Shane. Shane, can you go ahead and read number 1 for me, please?
Yeah, but one that says convictions, right?
Mm-hmm.
Dennis is on trial for robbery. Dennis takes the stand and testifies that he is innocent. Analyze whether the following convictions can be used to impeach him. A. Dennis was arrested for tax fraud last year.
All right, so 1 second. Prosecution versus Dennis. And then it says Dennis takes the stand and gives live testimony, essentially, that he is innocent. All right, so D takes the stand, testifies that he's innocent. What we need to know, Shane, is that the implications and consequences of him taking the stand to say that he's innocent is that he can now
be impeached.
Exactly. So the prosecution wants to bring in some following convictions, right? And all these different hypos to see. So the prosecution is bringing up these convictions. First one is arrested for tax fraud last year. I don't even need you to look at these rules. You should know by now already with this, Shane, if this is going to be admissible. And what's the answer?
It's not, because it's an arrest. It's not a conviction.
Ooh, you didn't fall for the trap there, right? This is the section, guys, of impeachment by convictions, not impeachment by arrest. If you're arrested for something, you still need to go to trial and get convicted. So this is where they try to trip you up, okay? So this is not going to work. What this does trigger, though, is another section. You have to see if the rules are met for that later, but that's prior bad acts regarding truthfulness. But not conviction. All right, go ahead and do B, Shane.
Dennis was convicted of tax fraud last year.
Another easy one.
Yeah, so yes, because it's a crime involving dishonesty or creaming falsity.
Yep.
And it's within 10 years.
Exactly. And just as a make sure we're understanding that, when we're trying to figure out the likelihood of it being admissible, what are the 2 questions that we're essentially asking ourselves once we know it's a felony?
Is it within 10 years? And then who is the witness?
No, in general, the 2 major questions is it a crime and falsity? And then how old is it?
Okay.
And then also, yeah, definitely, if it's a not crime and falsity, we know we have the additional question of which type of party are we impeaching, the defendant or non-defendant witness. Okay, so that's B. Let's go ahead and go with Victoria on C. Dennis was convicted of tax fraud 11 years ago.
I said no, because it is outside of 10 years.
Okay, but you got to definitely give me more. So because it's outside of 10, but what else are you using to then tell me what standard you're applying and then why it's likely inadmissible? But simply the fact that it's outside of 10, that's not going to be enough to get the right answer on the MBE or the essay.
Oh, so would it be, it's the reverse 403 is what we would be applying?
Exactly. And reverse 403 has a presumption of inadmissibility. And so from that perspective, yeah, now here, the tax fraud of 11 years ago, likely denied. Awesome. Victoria, let's do one more. Dennis was convicted of felony burglary last year. All right. So the felony now is burglary. All right. And it was last year. Before you give me the outcome, tell me what is the standard that we are applying?
do you mean? Oh, felony? Non-crimin falsy? And within 10 years. So, yes, impeaching the defendant.
Well, that's the next question, is impeaching a defendant. So now, since you know we're impeaching a defendant as well, what's the standard under impeaching a defendant?
The probative value is greater than the prejudicial effect.
And so that is our standard. And then I gave you the practical way that we're actually going to analyze that standard. And it's in determining whether or not the felony at hand is the same or similar to the crime that he's being currently charged for. This is being a current charge for robbery. Is this the same or similar crime to robbery?
Yes.
Now, this is how freaking crazy that this, like what the standard is for allowing this in. In this regard, even though you might think burglary is kind of close to robbery, that's still going to be different enough for where this likely will still be admissible, that the probative value is greater. If this was an essay, guys, I'm all for you analyzing both ways and saying that this is likely too prejudicial. But what I'm telling you, based off of these MBEs and where this usually lies, even when it's like that close, it's still not close enough to be the same or similar for this to be inadmissible. This will likely be admissible as the probative value still outweighs the prejudicial effect. Okay. Jordan, you have a question?
This is a quick question. When we're applying, when you say reverse 403, you mean like the legal, like the legally relevant 403, right? With
the evidence is admissible as long as the probative value is not substantially outweighed by the prejudicial effect.
Okay, got it. So on the essay, do we put so for C was a no because outside of 10 years and it's reverse 403. Can we just put reverse 403, or do we have to say, and the probative value of admitting the tax fraud conviction is substantially outweighed by...
I don't remember that specifically. It'd be nice if you can remember how to phrase reverse 403, because why not?
Right, yeah.
But I don't remember if they actually do that. So put a question for yourself as you go through the essays to see. Conviction doesn't come up all that often, so you're not going to get a ton of essays on it, but you can use your materials to identify one. But yeah, it's just the opposite. So you should be able to do it. Reverse 403 is the evidence is inadmissible unless the prejudicial effect is substantially outweighed by the probative value. So you're pretty much just switching everything. Yeah. Ani?
So for MBE purposes, should we say that it should be the same underlying crime? Because how similar is similar?
That's
robbery.
Yeah, that's a bit.
Robbery and burglary is not similar. Then what else could be similar?
Similar enough. Yeah, that's a very good point. Yeah. For our purposes now, I think that's good enough because, what is then similar enough to then make this more prejudicial? Yeah. So I would say until you see it in a specific example of what is considered similar, I would say what would be similar enough is larceny and robbery, right? Because we know those have essentially all of the same elements, plus they have two more. I think that would be enough that if, robbery was here and this was a felony larceny, that would be too much. But since burglary is more about because the thing about burglary is that you don't even actually have to go in and, take anything. Whereas with robbery, you do. So when you get into the elements, you can kind of draw the difference. So does that help out a little bit, Ani, with what your concern is?
Yeah, that helps.
Cool.
Thank you.
You're welcome. All right. So let's move on to the next one. Let's go with Michelle. Michelle, so it says Dennis now was convicted of felony burglary 11 years ago. So similar, but now different. It's still a crime non and falsy, but now what's the case?
Okay, so we're doing the non-falsy crime. No, wait. Hold on, I need to. Oh yeah, and then we're doing outside of 10 years, and we're applying the reverse 403.
And we know that when we're applying reverse 403, the presumption is that the conviction evidence is going to be
inadmissible.
There we go. All right, Michelle, one more. Dennis was convicted of robbery last year. So you do robbery and you do last year. Okay.
We're doing impeaching the defendant, but it's the same crime, so it doesn't come in.
It's too prejudicial, so it violates the rule and does not come in. Exactly. And then if Dennis was convicted of robbery 11 years ago, well, this is definitely grounds for violating reverse 403. If you needed any additional grounds, this is not a crime in falsity. It's older than 11 years ago. It's the same exact crime, right? All these things would add up, and you would not admit the robbery of 11 years ago either. You wouldn't even admit the robbery of last year. Why would we admit the robbery of 11 years ago? Okay. Note, here are some ways to illustrate how the conviction evidence can be introduced. The prosecution, as you're trying to get the flow of how this comes up, there's a note in your answers that says, here are the ways to illustrate how the evidence will actually come in. The prosecution can cross-examine Dennis after he testifies and ask him if he was convicted of the crime. The prosecution can choose not to cross-examine and simply introduce a copy of the conviction record. And then the third, the prosecution could call a witness like a police officer to testify as to their knowledge of conviction. So that is also essentially what your triggers are for conviction coming in to impeach, is through one of those three ways, right? This person has testified, and then the prosecution does one of those three things. And to that point, I'm going to go ahead and make a note real quick. I think I like the idea, Ani, of adding in another letter here, E, focused on larceny, which would then be likely similar enough for that similar conduct to then also be excluded. Cool. All right, guys. Any questions on convictions before we move on? Yes, Vanessa.
With attempt crimes that are the same as the crime that the defendant is on trial for, would that also be similar enough?
I would definitely make that argument, yeah, right? So if it's like you're on trial for murder and then you're bringing up a felony conviction of attempted murder, I think definitely you make the argument. And if I were to see that on an MBE, I would go with too prejudicial if you're impeaching the defendant and therefore excluded. Yeah, awesome. Okay, so let's do a quick little recap, guys. Hopefully, again, I'm trying to teach you with the sections that we can get away with it, how to game the bar exam. And hopefully from this, right, not only did you have the rules and the standards to apply, but also a good sense of where your likely result is going to be. And do realize that for this, right, section, as you see in this chart, it's not so much about a true detailed analysis of these standards. It's about knowing how to know which standard is the standard to apply and then what is the likely scenario under that standard. But it's not so much about these super case-specific analysis of the standard. All right. So again, Ani, when we're asking ourselves whether or not we're going to admit this conviction to impeach, if we know we're dealing with a felony, what are the two major questions we want to be asking ourselves?
If it's the crimen falsi, or if it's how long has it been? If it's within 10 years or outside of 10 years.
Exactly. And essentially the answer to these questions are going to either support admissibility or hurt admissibility. What's the answer to the crimen falsi question, it is or isn't, that helps admissibility? If the conviction is of a
similar or same.
No.
The underlying.
Regarding crimen falsi, what's the answer to that question that essentially supports admitting the conviction? And the answer is when it is a crime in falsi, right? And so then when we're asking the question of is it within 10 years or older than 10 years, what's the scenario that supports admissibility?
If it's within 10 years.
Exactly. So we want to know, right? We want to, as we're getting comfortable with these rules, we want to sense some level of hesitancy if it's older than 10 years and some level of hesitancy if it's not a crime in falsi. Although we know that even if it's not a crime in falsi, is if it's within 10 years and it's the criminal defendant, it can still come in, right? And we ask another question, is this the same or similar conduct? So try to make sure you just have a good flow for this section. But again, I feel comfortable now for us as a group moving on, knowing what your responsibilities are for answering these questions correctly. Yadi? You have a question?
Yeah, at the beginning of the section, you listed the dishonest or
Crime and falsies?
yeah, so you listed the types of crime. Are they in our blueprint, or can you
That's
just
in
repeat
that,
them?
that was in the chart. It's in the box on your chart. And
Oh, yeah. Okay, I see it. Never mind. Got
perfect.
it. Thanks.
You're welcome. Yeah, so look out for those, right? Those are your crime and falsy ones. All right. So let's now move on to impeachment by prior bad acts regarding truthfulness. Okay? Impeachment by prior bad acts regarding truthfulness. So let's start off with our blueprint. We only have 2 more sections of impeachment good, so we're almost done with impeachment. We're going to cover these last 2 sections together and then do the hypos. Okay, so last 2 sections, right? So let's get out of convictions, right? We're no longer dealing with convictions. Let's say it's prosecution versus DeAndre for robbery. Let's say DeAndre calls Ani to the stand, and Ani just testifies that, yeah, he was with me on the day of the robbery, right? So this is a robbery. He was with me on the day of the robbery. Ani, since you took the stand, the prosecution may now want to do what?
Impeach me.
Impeach you. Now, the attorneys for the prosecution are going to be looking into your history and trying to figure out how can we impeach Ani, right? And then they're going to stumble across some things that are like, oh, she's engaged in a little bit of suspicious behavior in her past regarding her truthfulness, right? So let's say they came up with the fact that you lied on your law school application. You said you had a 170 on the LSAT, but really you had a 165, okay? And so now they want to bring that up. That's a prior bad act regarding truthfulness, right? I want you guys to realize before we get into these rules, like kind of just like go from this angle, there's essentially 2 ways they can try to bring this in to impeach Ani, right? When Ani gets up there and testifies about whatever she testifies about, DeAndre wasn't there, he was with me, etc. They can do one of 2 things. They can impeach Ani regarding this whole lying on the law school application by cross-examining her and questioning her about it. Or maybe, what can they do? It's another practical way to prove that she lied on her LSAT law school applications. Ani, what's another way to prove that?
Introduce evidence of me lying.
Exactly.
Like the LSAT score, maybe?
Maybe the LSAT score. Maybe you just bring in the actual admissions person from the law school to testify that, yeah, we received her application and determined that she lied on it. So that's then bringing your own witness. So I want you to see that these last 2 sections represent those 2 options. Prior bad acts regarding truthfulness is something that you do on cross-examination, and you can inquire into specific instances of conduct. Bringing your own witness is trying to bring your own witness to do just that, right? Talk about how this person can't be trusted. Now, based off of looking at this rule, let's look at bringing the own witness first. Ani, looking at that rule, would that be admissible if you took the stand on my behalf and testified in my favor? Then they brought the admissions office director to say that you lied on your law school application. Is that going to be admissible under the rule for bringing own application, bringing your own witness?
Yes.
No, I don't think so.
Oh, wait. Is not trustworthy.
What's the general rule say at the very beginning for bringing own witness?
A witness may be impeached by reputation or opinion evidence offered on direct examination.
Exactly. So we're going to get to the basics of this later, but we got to do it a little bit now. If your prosecution, Ani, is calling their own witness, let me write this a little bit bigger too so you can see. Admissions director, and then, yeah, they brought Ani here. If you're bringing in the admissions director now to impeach A, this is now on direct. You're bringing your own witness, that's called direct. Now, it says here on direct examination, you can only offer opinion or reputation evidence. Here, we said we're bringing in the admissions director to testify as to what, Ani?
As to my truthfulness.
But specifically how? We're bringing in that person to say that she did what?
That she saw my score.
And that you lied on your law school application, right? So bringing in like the evidence that you lied on your law school application, that is specific instances of conduct, which is not allowed on direct to impeach. So this would not be allowed. So if you wanted to use specific instances of conduct to impeach, what would you have to do? Per our rule above, you're going to have to do that on cross-examination. You can't bring in the admissions director for that specific instances. You have to cross Ani while she is still on the stand. And you said, Ani, you just testified that DeAndre was with you on the scene of the crime. I get that. Okay. But isn't it true that you lied on your law school application 2 years ago? Going through our rule, is that questioning of you on cross-examination going to be admissible, Ani?
Yes.
The answer is yes. Here, is that question related to the witness's character for truthfulness? Yes. We're talking about her lying on a document or on an application. Is this introduced on cross-examination? The facts say yes. And then you have to do 403 balancing. And there's no reasons why this shouldn't pass 403 balancing. So therefore, this is admissible as a prior bad act regarding truthfulness. And then what does it say as the number 4 section under prior bad acts regarding truthfulness, Ani?
Extrinsic evidence. No extrinsic evidence is allowed for prior bad acts regarding truthfulness.
And that's another way to look at trying to bring in the admissions director. You have to do it on cross. By bringing in the admissions director to prove that, that is then bringing in extrinsic evidence. So you can't do it under that rule anymore. But then you would try to do it under bringing your own witness. But however, under bringing your own witness, you can only do opinion or reputation testimony, and neither of those are here. But if you brought in the admissions director to simply say, well, the admissions director says, in my opinion, Ani is not a trustworthy person, that would be okay. Any questions on that before we do a few examples? All right, Yadi, pretty straightforward. Cool. All right, so let's go ahead and look at these examples. So, number 1, Patrick is suing Donna for battery. Okay. Patrick versus Donna for battery. Patrick calls Wendy to the stand to testify that she saw Donna hit Patrick, right? So just live testimony of observation, eyewitness testimony. Analyze whether the following impeachment methods will be, or attempts will be allowed. All right, so let's go with Jesse. Jesse, based off of these base set of facts, we called Wendy to the stand, so we know who can be impeached.
Wendy.
Perfect. First one says, Donna's attorney responds by calling Bishop to the stand. So Donna's attorney calls Bishop to the stand to Wendy's employer. Bishop testifies that Wendy lied on her job application. All right. Is this going to be admissible? And in theory, you could go down the entire list. Wendy can be impeached. Is this bias or motive?
Yes.
Wendy, what bias or motive would Wendy?
Oh, no.
Yeah. No bias or motive that Wendy has, so not there. Is this prior inconsistent statement?
No.
No, there's no inconsistent statement, a prior one by Wendy. This is not convictions. There's no evidence of convictions. So again, remember, all apply to every scenario, but you have to realize what, if any, are the reasonable methods to discuss. So here we're going to again focus the rest of our discussions on all of these hypos on prior bad acts and bringing your own witness. So is this going to work under prior bad acts regarding truthfulness, Jesse?
No.
Why?
Because it's not on cross.
Exactly. Prior bad acts regarding truthfulness only works on cross. Why is prior bad acts regarding truthfulness triggered?
It's related to her character of truthfulness.
Exactly. That this is a prior bad act regarding her truthfulness, right? So it is triggered, but it's not met because it wasn't a question done on cross-examination. We got to be able to quickly see that without second guessing ourselves, guys. So good job on that one, Jesse. Next question is, will this work under bringing your own witness?
Yes, because it's on direct.
On direct, though, what type of testimony is allowed on direct?
Reputation or opinion.
And is this one of those two?
Oh, no.
Exactly. Jesse, from this, we should be able to now realize and see that there are really three types of evidence that we're dealing with in this world, right, of impeachment regarding truthfulness, this prior bad acts, etc. There's opinion testimony, there's reputation testimony, and then there's, what's the last one? Specific instances of conduct. Right? Do you see those three now? Those are your three options?
Yes.
So opinion testimony and reputation testimony only allowed on direct. Specific instance of conduct, and in this regard, would be whenever you're doing prior bad acts. Prior bad acts, in other words, specific instances of conduct, only on cross-examination. So when you're doing this example, right, you can see that this is not going to be prior bad acts regarding truthfulness because of the rule in which it has to be done on cross. It's okay that it's specific instances of conduct for that rule, but it's wrong in that it's not on cross. Then you get to the bringing your own witness. Well, that's on direct, and then on direct, you cannot do specific instances of conduct, only opinion or reputation. Is that clear?
Yes.
Cool. So from that perspective, this evidence will not come in under either of those rules to impeach. All right, let's go with B. Let's do one more together, Jesse. Now it says, Donna's attorney responds by calling Bishop to the stand. Bishop testifies that Wendy has a reputation at work for lying. Is this going to be admissible to impeach Wendy? Yes or no?
Yes, because it's on direct and it's reputation.
And so this will come in under which rule for impeachment?
Prior bad acts regarding truthfulness?
No.
Bringing own witness.
Yes, under bringing own witness, right? You've called your own witness. You called Bishop, right? And then this was the proper type of testimony here in that it was reputation. Realize too, whenever you're, Jesse, look at the board for me for a second. Whenever you have the person is calling another person to the stand to impeach, by the basics of prior bad acts, knowing it has to be on cross, this can never be prior bad acts regarding truthfulness because it has to be done on cross, and you're doing it by bringing a new person, right? So we can always think of that for short as well. Okay, let's move on to the next. By the way, I'm curious, Jesse, what do you have set up for your tech setup? Because I realized, yeah, exactly. So do you have
I'm not looking at you.
Yeah. So how do you have that set up? Just out of curiosity.
I have an external screen because I have really bad eyesight, so I bought a bigger computer monitor and just have it dual between my laptop and the monitor.
Got you. Okay, I'm like, she giving me the Magic Johnson no look. I was like, look at the board. She was like, I'm like, that's not the board. No, it's all good. I figured you. I was like, that's why. Okay, she must got something going on. Awesome. Okay, so then let's go now to Vanessa. Vanessa, can you do C for me, please?
Donna's attorney responds by calling Bishop to the stand.
Pause for a second. I'm so sorry to do that to you. Pause. Donna's attorney responds by calling Bishop to the stand. At that very moment, in the world of impeachment, we know what's not going to work.
Opinion or reputation? No, wait, that's direct. We are on direct, right? Donna's attorney responds by calling Bishop to the stand.
Exactly.
That's on direct. So specific instances of conduct won't work.
And that's connected to prior bad acts regarding truthfulness. That's one of your categories.
Yes, I'm still absorbing some of
Yes, it's okay, but I still want to test you in the way that I expect you to have it. And so remember, prior bad acts regarding truthfulness is one where you do it on cross-examination. If you have now called your own witness, you are out of cross-examination. You're no longer cross-examining that person. So, okay, so Donna responds by calling Bishop to the stand. Okay, what does Bishop testify?
Bishop testifies that Wendy has a reputation at work for lying. So that's okay.
Okay.
His reputation. Then Patrick, who's Patrick? Oh, Patrick's still in Donna. Sorry, I missed that part. Okay, sorry. Patrick then calls Chris, who is Wendy's coworker, who testifies that Wendy is an honest person.
So we haven't talked about this yet. What is Patrick now trying to do?
Essentially, he's doing what Donna did. He's calling someone to rehab Wendy.
Exactly. And we haven't talked about this rule yet, but do you think that once a person's credibility is impeached, that they have the opportunity to rehabilitate that witness?
They should, yeah.
Right? That's only fair. You can't talk mess about me, but not giving me a chance to say you can believe me. So that's the takeaway from this question, is that Bishop's testimony is admissible for the reasons you stated. Chris's testimony is also admissible because one can rehabilitate an impeached witness by bringing their own witness and adhering to the same rules of opinion or reputation testimony. Okay? So takeaway is you can rehabilitate, but you got to follow the same structure. All right, one more, Vanessa. Do D.
Okay. Donna's attorney responds by cross-examining Wendy. On cross, Wendy is asked if it is true that she was arrested for tax fraud last year.
Okay, so now we see one structural difference. Instead of bringing Bishop, what took place?
Donna's cross-examining Wendy.
Exactly. There's cross-examination. So we know we cannot do impeachment by
opinion or reputation.
And use it when I say that, Vanessa, do it by the method that requires that. So we cannot be impeaching by bringing on witness. Exactly, by bringing on witness, because Donna didn't bring her own witness. So, but now we're on cross-examination, all right? And so here it says, is it true that you were arrested for tax fraud last year? Is that a prior bad act that relates to truthfulness?
Yes, it's a crim and falsity. So don't we have to go back to that?
Well, we're not bringing in a conviction, though. That's the thing. We're not bringing in a conviction. And it also says here, wasn't it true that you were arrested? Okay. So even more reason why we're not going back to conviction, right? Because it's not bringing in a conviction. It's just an arrest. But being arrested for it would be enough to be a prior bad act. That's what I was saying to Shane when he caught that last time. Yes, this is not a conviction, but it could be a prior bad act. And so here, it's on cross-examination. You're asking it, is this ultimately going to be admissible?
Yes.
Yes, it's a prior bad act regarding truthfulness. It is on cross-examination. It should pass 403. There's nothing to say it shouldn't. So it should be admitted under prior bad acts regarding truthfulness. All right, let's do the last two. Let's go back to Shane. Shane, go ahead and read E for me, please.
Donna's attorney responds by cross-examining Wendy. On cross, Wendy is asked if it is true that she was arrested for tax fraud last year. Wendy responds, no. Donna's attorney then seeks to call Officer Adams to testify that he was the officer that arrested Wendy for tax fraud last year. So I think the question is fine, but the introduction of calling Officer Adams, that's not okay.
Under what rule?
Under extrinsic evidence.
Exactly. So let me break this down for everybody to see clearly. We had three things that happened here. We had the question on cross-examination. We had Wendy's response of no. And then we had Donna going a step further to bring somebody to further develop what was just asked on cross-examination. So it was cross-examination, and then they also brought Officer Adams, right, to testify as to something. It's time for this marker to go. So the question on on cross is admissible for the same reasons that Vanessa just said a second ago. Prior bad acts regarding truthfulness on cross, no 403 issue. The response obviously is admissible. That's Wendy's response to the cross-examination question. Now, could Wendy be lying on cross? Yeah. What's the punishment for that, Shane, if she was lying and when she said no?
Aren't they just stuck with the answer? They can't do anything about that.
That's not my question. My question is, what is her punishment going to be for lying on the stand? If she said no and that was a lie, the punishment is perjury, right? That's perjury. You took the stand and you lied as to a question on the stand. But to that point, even if she's lying and she says no, that doesn't mean this side now gets to bring in somebody else to prove that she is lying. They're stuck with asking the question on cross, and whatever her answer is, even if it's denying it, even if it's lying and denying it, they are not allowed to bring somebody else in to support the argument they were making with their question on cross. Does that make sense, Shane?
Yeah, I got that.
Good.
So I just looked at the answer after I didn't look at it before. I knew the question wasn't okay. I don't know if it's a typo, but it says the question on cross-examination is admissible for the reasons discussed above. Did you mean that?
This question is admissible. The original question of
the first part.
Yes, the first question. That's the only question.
Okay, but the introduction of the officer, that's not okay.
Yeah, it's not a question, Shane.
Yeah, okay.
You got a typo in your head. Don't try to play me. Don't play yourself. All right, mess it up. Go ahead, Rosemary. What's your question?
I have a question because comparing that to contradictory facts, how are those two like that's like one of the first things that popped into my mind was contradictory fact where she said no and then he said yeah, I arrested her. So how can you distinguish both of them?
Yeah, I see what you're saying. I would say that because Rosemary, you have now entered the world of the situation, starting off with prior bad acts regarding truthfulness, right? So Donna's attorney responds by cross-examining Wendy. And the thing is that you're dealing with the initial impeachment evidence based off of, right? She took the stand and said that she saw Donna hit Patrick. So for it to be contradictory facts, Rosemary, it needs to be contradictory facts around what she saw as the original means for impeaching her. But the original means for impeaching her is asking her this question about this unrelated to the incident at hand event of her lying on something, right? Or her doing tax fraud. So that is what starts then now the path of prior bad acts regarding truthfulness. And once we've gone down that path, you're then following what the subsequent rules are for that section. You're now talking about contradictory facts within the prior bad acts, but you don't want to think of it that way. Once you're not in contradictory facts because you didn't start off by giving contradictory facts of who hit who, which was the live testimony. Does that make sense?
Yeah, it makes sense.
Yeah, it's just like don't mix those two together. It's like which one are you using to start, and then you're just following the framework of that one. Okay?
Wouldn't it also be like a collateral matter?
Louis, man, I know I was talking about your room, but you ain't got to black your screen out, bro. I was just playing around.
No, sorry. Like,
all right, what was you saying?
But for the contradictory facts, wouldn't the whether or not she was arrested also be a collateral matter, and you can't use like extrinsic like evidence for that?
For contradictory facts?
Yeah. Whether or not she was like arrested.
I personally wouldn't want to go into too many reasons as to why it wouldn't be contradictory facts. To me, it's just like it's not even giving the initial trigger for it. Contradictory facts would have to go to what she originally testified about. So the fact is she's testifying that I saw Donna hit Patrick. So contradictory facts would be I'm impeaching her by bringing some type of evidence that it was actually Patrick that hit Donna. That's the only way to trigger contradictory facts. But the method of impeachment is by going through this route of saying she committed tax fraud. So that's why we're just not in contradictory facts. And I just want to keep it at that surface level because that's all that you guys need to do.
Got it.
Cool. All right. So was that the last one or we have one more? We have one more. Shane, go ahead and do the last one, F. Shane left. He had to go fix his own typos. So F says, Donna's attorney responds by cross-examining Wendy. On cross, Wendy is asked if it's true that she arrested for is it true that she was arrested for tax fraud last year? Important additional sentence. Donna's attorney knows that Wendy was never arrested for tax fraud. This is testing another nuanced rule where, as an attorney, when you're doing cross-examination questions, you can't simply just make up BS prior bad acts to ask about that you have no factual basis for. It doesn't have to mean that you're accurate and they actually did it, but you at least have to have some good faith in your request on that questioning, right? So whenever the facts are saying that the person is making up that and is doing it in bad faith, that's not cool. You cannot ask that type of question on cross, okay? So that is the hypo testing that concept. All right. We are done with impeachment. Matt, you got a question for me?
Yeah, just really minor, that last one you just said, is that something, I remember you said once in a while the PR and evidence, is that kind of a little PR issue right there?
Yeah, if we have Donna's attorney knows that Wendy was never arrested for tax fraud and did something like that, yeah, if you had an evidence PR crossover, that could be definitely something that trigger PR. But you don't ever have to really second guess if it's a PR crossover, because they'll also ask you in the call of the question, please analyze any ethical violations committed by the attorney here. But yeah.
Got it. Okay.
Cool. All right, so that's impeachment. Matt, I'm going to go ahead and stick with you, man. Can you remind me, please, what is the difference between impeachment and a majority of the other rules that we have learned today?
So the majority of the rules we were learning today is to prevent something from coming into court, whereas impeachment is just, it's not that it's not allowing something in court, it's just calling a question to something that was brought into court, like saying, hey, well, something else happened earlier, let's clarify this issue. Whereas the other rules are saying, no, this can't even be let in.
Exactly, right? So impeachment is more so grounds for admitting evidence on the grounds of impeachment. Exactly. And then from there, we learned who can be impeached. Who are the two different types of parties that can be impeached?
It would be the actual, it would be any witnesses or the person who's advancing some sort of argument like this.
It'd be the witnesses that take the stand and any declarants of hearsay statements, right? Rare scenario, but declarants of hearsay statements can also be impeached. And then lastly, how many can you remember? How many of the impeachment methods did we have? How many can you remember?
7.
Yep.
That there's a bias and motive.
Yep.
Prior consistent statements.
Yep.
Prior bad acts regarding truthfulness. Convictions.
Yep.
Oh, sensory mental defects.
Mm-hmm. And I think one more.
And calling an own witness.
Calling your own witness. And then the other one is actually 2 more. The other one is contradictory facts. And here's the way I remember it, guys. You know, if this helps you guys in the future, you got the 2 basic simple ones, right? Bias, motive, sensory or mental defects, right? The 2 easy ones to throw out the way. Then after that, you have the 2 that are related but different. You have contradictory facts followed by prior inconsistent statement, right? And then after that, you got convictions. And then after convictions, you have the 2 again that are related, and that's prior bad acts regarding truthfulness and then bringing on witness. All right, guys, we are done with impeachment. So the next topic for us to cover is character evidence.